Good afternoon, everyone. Thank you for coming to this session. So we're going to tackle today counsel ethical conduct in the context of international arbitration. And to make it interesting, we thought we'd use a format of Q&A with our two panelists. So to my right, I have Joel Richler, who's a senior member and past co-chair of Blake's Litigation and Dispute Resolution Group. Joel, in addition to having practiced before all levels of court in all Canadian jurisdictions, has also appeared before the Federal Court of Appeal and Supreme Court of Canada. Joel has actively been involved with several arbitrations, both as an arbitrator and counsel before the Chartered Institute of Arbitrators, the LCIA, the ICC, and ADR Institute of Canada. Joel is a fellow of the Chartered Institute of Arbitrators, and he's also founding member, past treasurer, and current board member of the Toronto Commercial Arbitration Society, and a member of the Users Council of the LCIA. He has received numerous awards and recognitions, including Chambers Global, the world's leading lawyers for business 2013 in dispute resolution and arbitration in Canada, and has been recognized in the Canadian Legal Expert Directory 2013 in the fields of, amongst other things, arbitration. He was also named Best Lawyers 2013 Toronto Alternative Dispute Resolution Lawyer of the Year. David Stolow from Davies specializes in civil and commercial litigation and arbitration, both as counsel and arbitrator. He has successfully argued cases before all levels of court in Quebec and before the Federal Court of Appeal and the Supreme Court of Canada. David regularly acts in domestic and international arbitrations across a wide range of areas, and I can personally attest that he is a formidable adversary. David has been recognized in 2014 in the best lawyers in Canada in the areas of bet the company litigation, ADR, corporate and commercial litigation, and was named by the best lawyers in Canada as the 2014 Montreal Alternative Dispute Resolution Lawyer of the Year. Finally, David has also been recognized as a 2014 Future Star in the arbitration and commercial litigation areas by Benchmark Canada. So well done, gentlemen, and let us go to our session. Counsel ethics, it would seem, is important and I would say indispensable in the fair conduct and efficiency of arbitration proceedings. It is, however, less clear what would constitute unethical counsel behavior in the context of international arbitrations, and to determine which rules or guidelines or codes of conduct may apply and how a panel of arbitrator would use such rules or guidelines to sanction unethical behavior or egregious conduct by counsel in the context of international arbitrations. In the literature, we can see that there are two schools of thoughts on the subject. Some authors will argue that guidelines will simply lay out self-evident guidelines, which may not be that useful, whereas others will feel that these guidelines may hinder the prosecution of the arbitration process or even potentially lead to award annulments. So against this backdrop, I would put the first question to our panelists as follows, and I would ask Joel to respond first. Why is promotion of ethical counsel behavior important in the context of international arbitration?
Thanks. I think that the question really... Thank you. Thanks for the tip. I think that the question should start with a discussion or a consideration of why international arbitration is different than domestic arbitration, and that might lead you to a self-evident answer. And the difference between international arbitration and domestic arbitration insofar as counsel behavior is concerned is that you have lawyers that are appearing in front of tribunals from different jurisdictions, different from each other and different from the arbitrators. So the question then becomes, what rules, if any, govern? Is a lawyer practicing as counsel in a Texas-based arbitration subject to the ethical rules that apply in his or her own jurisdiction? Is that lawyer subject to ethical rules and guidelines that apply in Texas? Or are there some other ethical guidelines or procedures that apply that would govern the arbitration? Do you look to the institution, if there is one? There are different factors that come into play. And the second aspect is that closely related to that is that you have in an international context that you don't have in a domestic context. You have different cultures where some things may be self-evident to a lawyer practicing in New York. Those very same things may be antithetical to what lawyers practicing in Germany or France might consider to be proper. And then you have the fact that the arbitrators come from a different jurisdiction themselves. And the third thing that makes international arbitration different from domestic arbitration is that if you're doing a domestic case in Ontario, everybody knows that the Ontario courts have some sort of supervisory or jurisdiction over the process to some degree. And everybody knows that all the lawyers are subject to the same cultural considerations and the same rules. That doesn't apply in an international context. You don't have an obvious place to look to in order to regulate behavior. So there has to be some consideration given to ethical behavior and how that behavior is controlled if there is a problem.
Based on your experience, and maybe David, you could answer that question, is unethical counsel behavior an issue in international arbitration? Do we see it?
That's a terrific question. I mean, a lot of the criticism you'll hear with the adoption of new guidelines dealing with issues of conflict of interest, we'll talk about the IBA Guidelines a little bit and the new LCIA rules, is are we creating solutions to a problem that doesn't exist? And part of the difficulty with that question is well, first of all, the fact that we're talking about it and the fact that they've had, it's been talked about for quite a while over the past couple of years, and you have the adoption of these soft law instruments, at the very least, whether it's risen to the level of a problem, it's certainly risen to the level of consciousness among international practitioners that it is a subject worth discussing. How do we know if there is this problem in the sense that arbitration is confidential, or it's private, I should say? The vast majority of times it's confidential. We don't have tremendous amounts of data or information. That being said, you know, the IBA guidelines were the product of a task force that worked over a period of 2 years to look into this issue. And one of the conclusions was that there was a tremendous amount of uncertainty as to what ethical rules apply. So I would say it is a very important issue that, you know, and it's something that we probably take for granted on some level. You know, we were discussing it this morning. When you're dealing with a domestic arbitration, you know, Francis and I were involved in an arbitration on opposite sides. There was never a doubt in my mind or any form of debate as to whether or not Francis and I would be functioning according to the same ethical principles. Now, someone may say, well, what's the big deal in terms of ethical principles, right? Well, the big deal is the following. You're looking for a forum where you are going to have a fair, an independent, an impartial hearing. People are skeptical in many cases of having matters decided in international arbitration by the local domestic court, if you will. So you say, I'd like a forum that's going to be neutral, that's going to be reliable, that I can depend on. Well, you have the substantive law that governs your dispute. You will, in all likelihood, depending on the rules you've adopted, have the procedural laws that govern the dispute. But you are also asking your arbitrator or arbitrators to decide what presumably is a very important matter for your client based on, quote-unquote, historical truths, documents, witness statements, right? If both parties are not functioning according to the same ethical rules, that could lead to problems. And we'll get into that a little bit in talking about witness preparation and document production.
Just if I can supplement that, the problem, or part of the problem is that much of the information that we have is anecdotal. There's no documented or data that you can look to and say there's counsel misbehavior in so many cases, and this is the type of misbehavior that occurs. It is all anecdotal, and there was some degree of difference of view even amongst the drafters of the IBA guidelines as to how much of this problem was in reality a problem. The second comment I would add is that when you look at the guidelines, they're really addressing two different types of ethical conduct. There's discrepancies of ethical conduct just because people happen to come from different places, so that the rules, for example, for witness preparation in England will differ very much from the rules for witness preparation in the US. And what an arbitration panel has to do to the best that it can is level the playing field so that both sides in a case are playing by the same set of rules. That's the inadvertent difference, if you will. But then there's also the advertent difference, which is when you have knowing misconduct by parties. So if you look at the IBA guidelines, for example, they sanction or they purport to regulate or provide guidelines for differences in legal culture, whereas if you look at the rules just promulgated by the LCIA, those rules are targeting knowing misbehavior, so that you'll see a rule that said lawyers, for example, and I'm paraphrasing, that says lawyers should not knowingly mislead a panel, whereas the IBA rules will say lawyers should not mislead a panel. So there's a sort of a, you have to really focus on what you're talking about. Are you talking about knowing misbehavior, which some people use the expression guerrilla tactics, or are you talking about just differences in culture that present the difficulty that a tribunal has in making sure that both parties are using the same playbook?
Could you give us examples of differences in terms of witness preparation for written statements, for example? Do you have examples in mind that illustrates that divide between two different legal cultures?
I think most people in the room know, and that's probably the easiest one to talk about because it's the most obvious. I think most people in the room will know that whereas in Canada we have one view as to how much a lawyer can be involved in preparing a witness. Some people will use the expression woodshedding a witness for testimony, both cross-examination and direct examination. In England, there are far different rules that apply. It used to be that barristers weren't even supposed to meet the witnesses before the trials. I gather that no longer is the case, but there is a far less degree of interaction between a barrister preparing a witness in England than there is a lawyer in Toronto preparing a witness to give evidence. The other extreme, and I think we all know this as well, is in the U.S., and I was just down in the U.S. a couple of weeks ago and shown in the offices of one of the large firms, not a virtual courtroom, a physical courtroom, a full-sized, set-up courtroom. And the lawyer that I was talking to at that firm says that for every trial they do, every witness they call to give direct evidence goes through that trial process. It's a rehearsed trial with a judge and jury and opposing counsel 3 or 4 times before the trial starts. And I was talking about the differences with that particular lawyer, and he made the point that their firm feels that if they do not do that, and if they're unsuccessful and they have an unhappy client, they could be exposed to negligence claims for not having prepared the witnesses properly. So what will constitute categorical unprofessional behavior or misconduct in the UK will constitute a standard of behavior in the US. You have an international arbitration that takes place between a British company and an American company in front of an arbitrator who's from Germany. That arbitrator may or may not be sensitive to the differences that take place. A good arbitrator should to deal with that in advance, and I suppose we'll talk later in the hour about ways and means that arbitration tribunals can deal with these issues. But if the tribunal is not aware of the difference, it becomes inherently unfair. Now, if a witness is over-prepared, that may be obvious, but it may not be obvious. And that difference is one which is rather stark, and that difference is addressed in the IBA Guidelines, where the guidelines say, and I'm paraphrasing, that lawyers are allowed to meet with witnesses and discuss the evidence, but that's all it says. It doesn't describe how that discussion should take place, what form it should take place in, and the extent to which lawyers should or should not be involved in actually rehearsing the evidence before it's given.
David, what about production of documents?
Well, that's what I was going to say. I mean, the other major area is document production, which plays a hugely important role in arbitration, international arbitration. From my perspective, if I'm asked to produce documents, it goes without saying that I'm going to have some measure of control over the process and not simply say to my client, give me what you feel like giving me. And I'm certainly not going to withhold documents that are responsive or relevant simply because they may be adverse to my client's interest. Now, from my perspective, that proposition is self-evident. It's not always the case when you're dealing with practitioners from other jurisdictions. So what rules apply? Clients may feel that their attorneys in an international arbitration, when the rules are not clearly established in terms of ethics, that the other side may have an unfair advantage. And the question becomes does the party whose attorney is subject to the quote-unquote lowest standard have an unfair advantage? So again, the whole purpose is to ensure that the parties are playing on an equal playing field. And that means that they are communicating documents with the same understanding.
I think what's often missed in the discussion is that lawyers are agents for their clients. And I can say anecdotally that insofar as document production is concerned, I can recall a case that I did where before the panel was appointed, both sides, myself and my opponent, we got together and we drafted a set of procedural rules that would apply to the arbitration. It was an international arbitration. And I have to confess that I really didn't give much attention to the fact that I should have spoken to my client about what I was doing. It just seemed so obvious to me that you'd have some process for document exchange. My client happened to be French, very French, very
What does that
Gallic,
mean exactly?
very Gallic. And he, when told that there was some obligation to produce documents, looked at me as if I was some creature from Venus, and in a very European way looked at me and said, well, why on earth would I ever give my documents to the other side? And that's an issue that I probably should have addressed with my client before I actually made the agreement. But it just highlights the fact that I'm trying to make, which is that you speak of counsel behavior. Counsel are agents for clients, and the clients have to understand that there are these differences going into the process so that they can be brought into the process and know what's being discussed and agreed upon as those agreements are being made.
Isn't there the issue also of the duty of loyalty to the client and the duty of candor to the panel? Is there an issue there in terms of raising potentially unethical conduct?
This is part of the controversy between those that favor the IBA guidelines and those that don't. And it tends to be a Europe versus North America discussion. North Americans were very much supportive of the IBA guidelines, Europeans not. And the Europeans who argue against the guidelines make the point that the arbitration is between the parties, and the parties have to be on the same playing field. And parties are entitled to assume that they will have lawyers that are loyal to their interests. And if you start writing rules that impose limitations and restrictions on lawyers as opposed to the parties, you, the drafter of the guideline or the arbitral institution, are interfering in that lawyer-client relationship.
Yeah, that's also a very interesting question. I mean, at its core, as to whether or not an arbitrator actually, or arbitrators, have the actual jurisdiction, if you will, to address and sanction unethical conduct by party representatives. Because, I mean, at its core, it's a contractual agreement between the parties to submit a matter to arbitration. So the arbitrator has jurisdiction over the parties by virtue of the parties' agreement. But what about the arbitrator's jurisdiction with respect to parties' counsel or parties' representative? Some have criticized the adoption of guidelines by saying one of the criticisms is that you now have the arbiter of the dispute having to take on a role that is somewhat alien to arbitration in terms of policing, if you will, or sanctioning the ethical conduct of counsel. The flip side of that is, and some have advocated this position, which I happen to agree with, arbitrators have an inherent mandate, if you will, to maintain a fair and ethical process. So whether it's viewed from the lens of, you know, I don't necessarily think it's sanctioning party representative conduct, but if it's viewed from the perspective of doing what's necessary, or it's a necessary adjunct to maintaining the integrity of the arbitration, I think it's difficult to argue with the proposition and that they do have this authority, if you will. The question becomes is, well, how far can they go with it? Under what circumstances can it be applied? And what rules govern? Because the IBA guidelines are just that. They are guidelines. And we'll also talk a little bit about the LCIA rules, which came into effect in October. Now, while those rules will become mandatory for people who adopt LCIA arbitrations, the IBA guidelines are guidelines. So in the absence of guidelines, in the absence, or adopting the guidelines, I should say, in the absence of an LCIA arbitration, what rules does the arbitrator apply for sanctioning unethical conduct? And of course, the real key question is depending on how you look at it, you know, in a situation where you're dealing with unethical counsel, to the extreme, I would say, is that, you know, potentially opening up the award to attack in the sense of, is one party being deprived of its right to be heard? The flip side is can somebody argue as a result of unethical conduct that hasn't been properly sanctioned by an arbitrator, the process has been compromised? So it has practical implications. And the whole reason behind the adoption of these guidelines is the cases of, and I'm not sure if I'm pronouncing it correctly, if anyone in the room knows the pronunciation there, Hrvatska, I believe,
Yeah.
a 2008 ICSID case and another 2010 case, where the panels there had to deal with situations of an arbitration being conducted over a number of years, and at the 11th hour, right before the hearing is to take place, one of the parties nominates new counsel or appoints new counsel that is in conflict with one of the arbitrators. So the question becomes is, well, what do you do? Are you going to disqualify the arbitrator at that point because there's a conflict and a party has the right to select counsel of its choice? What do you do in those circumstances? And in the cases that we talked about, that I just mentioned, the courts, there was one in 2008 in Hrvatska and another one in the Remterol in 2010, and the courts came to similar conclusions but for different reasons. And so in one of the cases, the court actually said to counsel that sought, the party that sought to appoint this new counsel, that they weren't permitted to do so. But the question still arises, well, where is this jurisdiction coming from? Where do you have the right to do so? And some people have said, well, the various rules of deontology in your local jurisdictions already exist. We don't need anything more. Well, if Francis and I have an arbitration here in Quebec, that's fine. But if I'm party to an arbitration in Texas with a lawyer from England, is it the Quebec bar rules that govern me? Am I governed by the laws of the state of Texas? I'm not authorized to practice under those laws. And what happens when a party's representative is not a lawyer who is participating in an arbitration, who isn't subject to these legal ethical rules? What rules apply? The guidelines don't purport to answer that question, but these are all sorts of issues that arise for those, particularly the Swiss Arbitration Association has been very vocal in criticizing, if you will, the IBA rules. Not so much in terms of the rules themselves, which, as we talked about this morning, in and of themselves, most of the actual rules are not that controversial. Most of the controversy surrounds the notion as to whether the rules themselves are in fact necessary.
The argument against the need for rules really is predicated on the following simple proposition, which is that under the model law, which is the law that typically applies to international arbitrations, each party is entitled to a fair opportunity to present its case or present its defense. And it's the arbitration panel's obligation to the contracting parties to ensure that they have that opportunity. And the argument against the need for guidelines isn't so much that there's behavior out there that has to be regulated to a degree that it's not regulated now. The argument against the guidelines is that by defining certain types of behavior that has to be regulated, you're leaving other things unsaid. And you're also creating the opportunity for people to use the guidelines as a tactical means to upset the process. Whereas before, arbitration tribunals carried on for decades, if not longer, hundreds of years. The model law says everybody has a fair chance to present its case and make its defense. The tribunal has an obligation to the parties to ensure that that happens. And if that doesn't happen, because parties misbehave or counsel misbehaves, and that somehow has to be reflected in the way in which the tribunal manages the process after that misbehavior becomes apparent, and it has to reflect itself somehow in the award which is ultimately made, whether it's by drawing adverse inferences, making adverse findings of credibility, imposing cost sanctions on the parties. But historically, tribunals have not had the power to discipline counsel, and that's part of the rub. When you read for example, the Swiss Arbitration Association criticism of the IBA guidelines, they say, well, where does this come from that the tribunal has the power to sanction counsel? The contracting parties haven't given the tribunal that power. Typically, the arbitral institutions don't give the tribunals that power. I can't recall whether the ICIA rule gives them that power, but I don't think it does except under a basket clause. So it's problematic, and sooner or later there will be a case where a tribunal in Ontario, Quebec, or somewhere else will impose sanctions on a party's lawyer or ask that the lawyer withdraw him or herself from the case, and that will become a ground for challenge. The other way of looking at it, and the perspective that I have, is that arbitrators tend to be very conservative historically in not wanting to do things that will cause there to be any ground for reversal at a judicial review, on a judicial review basis. So arbitrators will be conservative before they will do anything out of the norm, and that would include imposing sanctions on a party, for example. And my own view is that arbitrators tend to be too conservative. It's hard for me to imagine a situation in Ontario, which is where I practice, where a tribunal will do something out of the ordinary to deal with out of the ordinary behavior, and then have the trial court reviewing that decision, upsetting the award on that basis, because as I think we all know, the standard for reviewing of the standard for setting aside arbitral awards in Canada is very high. It almost has to attain the level of corruption. So I tend to think that arbitrators are too conservative, and if they're too conservative, I'm not sure what difference the guidelines will make.
Yeah, I personally don't particularly agree with this notion, akin to this: if you build it, they will come; if you draft it, they will breach. I think unethical counsel are going to find ways to, through quote-unquote guerrilla tactics, to attempt to derail arbitration with or without the guidelines. And one of the criticisms being that arbitration is supposed to be flexible, and people don't want it to move towards the model of traditional litigation. I understand that, but arbitration has also evolved over the past 20 or 30 years, moving away from trade disputes to situations of massive arbitration with hundreds of $millions at stake. I personally would, and I don't think we're compromising on flexibility. I would rather the parties have a clear understanding of the ethical rules that guide their counsel in these matters, so that everybody's on an equal playing field.
So, but what would be those rules? I mean, would you consider the law of the seat, where the place of the arbitration, the state or the province where you're located? Is it an issue of a conflict of laws, or?
I don't think so, Francis. I think the answer has to be practical, because arbitration is, after all, a process which is supposed to be a practical solution to the impracticalities of litigation. And I think the practical solution is probably the solution that good arbitrators have used for a long time, which is that at the start of a case, at an initial case conference or at an early case conference, the tribunal should be canvassing with the lawyers what types of procedures will be followed, because a lot of what the guidelines deal with are procedures. So the procedures for document exchange, they're procedures for communication with the tribunal, they're procedures for discovery, procedures for witness preparation. A lot of that has been done by good tribunals at the early stages of arbitration, so that if, for example, there's an arbitration between an American and a Canadian, or an American and a French company, going in what the rules are. As I mentioned before, we had drafted rules that dealt with the very types of things that the guidelines deal with, that dealt with the obligation to produce documents in our particular case. We didn't deal with witness preparation because, quite frankly, we knew that we were operating on the same playbook. But had I not known the lawyer, if the lawyer from the other side happened to come from somewhere else, I have no doubt we likely would have discussed that type of thing in advance, or we would have discussed it with the tribunal at the early stage of the case. So the question then becomes, does the existence of the guidelines really change that? I would say the guidelines are salutary. They're not controversial. There's nothing in the guidelines that any of us would find surprising. So the guidelines probably at the end of the day serve a salutary purpose, a salutary role, which is to make sure that the types of things that they talk about are considered up front, so that you know going into the process that you have to consider these types of things. The guidelines, by the way, don't apply unless the parties agree they apply, or the tribunal, after consulting with the parties, imposes them on the parties, which, by the way, might be problematic in some cases. But if you, as David said, if you adopt the LCIA as the administrative body for your arbitration, you're going to have the LCIA rules, so you should be aware of them. But again, even they're not controversial. Who would disagree with the proposition that a lawyer shouldn't purposely mislead a tribunal? Or who would disagree with the proposition that a lawyer shouldn't knowingly withhold documents that are helpful or harmful to the case? None of us would find any of that surprising.
and I think to Joel's earlier point, a lot of it is a matter of perspective in terms of the jurisdiction that you practice in. You know, one of the criticisms of the IBI rules from the Swiss Arbitration Association is that they've tend to, they're trying to quote-unquote level the playing field, but by cherry-picking from rules or systems that are more familiar to certain, you know, North Americans as opposed to Europeans, for example. So that's the reason why when we look at these guidelines and say, well, you know, we were talking about it this morning, I would have no issue whatsoever adopting the IBA guidelines for an arbitration because that's the way we practice anyway. But if I was a UK barrister who is not used to this practice of woodshedding, or an Italian attorney who may not be used to the practice of having to produce documents that are adverse to his or her client, now I'm in new territory. But I don't really see an issue with the guidelines per se, the individual guidelines.
So let's talk now about witness statements. Joel?
That's sort of related to witness preparation. And again, I think we all know that one of the common practices in international arbitration is the use of written testimony as opposed to oral testimony for direct evidence. Here too, there's a lot of variance in the practice, but typically what happens, and I think this is probably typical of the practice in most of the world, is that the lawyers will draft the statements. So the question then becomes, are there ethical issues that pertain to that? And there you would have, and I'm not talking about intentional misbehavior here, but you'll have differences in practices between some jurisdictions. The witnesses will be very, very active participants in all of the drafting, whereas in other places, for various reasons, they may not be. I think, Francis, you mentioned a case to us this morning where witness statements were prepared in English, drafted in English, they were always in English, for witnesses who did not speak English and didn't understand English, but who were asked to adopt the witness statements as their own evidence. I won't steal you might want to comment on that.
No, well, the point was I had 7 or 8 witnesses that were for the other side and filed written statements which were all in English. And my first question in cross-examination was, could you please read the first sentence of your witness declaration? And the witness could not do that. And not only one witness, but 7 witnesses out of 8. And nothing transpired out of that, which was kind of surprising. I mean, in terms of admissibility of the evidence or challenging its probative value. And no one seemed fussed about it in terms of counsel on the other side. I thought I'd scored great points. And it didn't make any difference, I gather, in the appreciation of the evidence by the panel. So I found that strange, to say the least. To a lesser degree, in that same case, we elected to conduct this ICC arbitration in opposing counsel's law offices in New York. And on the day of the submissions, we came into the room and there were these 56 demonstratives, blown out placards of emails highlighted in yellow that told a story that did the whole room. And I mean, that for me was guerrilla tactic. I don't know if, you know, it falls down into the realm of ethical or unethical counsel behavior. But I think it's worthwhile to make sure that you understand the logistics behind the place where you're going to conduct your arbitration, especially when it's at opposing counsel's place of business.
Just on witness statement, the fact of the matter is witness statements are the purest example of expediency over value. The expediency of making direct evidence short and quick and easily digested over the value of having somebody actually tell the story. And what lawyer doesn't know that when a witness testifies, the story always comes out different than it does when you're preparing the witness? It always happens. Always. Always. So, you know, is that an ethical issue or not? I mean, I think the problem that, Francis, you faced is that the tribunal accepted the weaknesses of the fact that they were written statements, and they accepted that as part of the price you paid for expediency in arbitration. And they didn't view it as cheating, but it may have been. I told Francis this morning I had an example where I had a written statement from a witness, and I asked, and the lawyer who had written it, instead of using the simple English word theft or steal, used the verb purloined. So I asked the witness what purloined meant, and he had no idea. Not a clue. And he spoke, English was that person's first language. So again, it's a written state, there will be different practices, and I think the practical solution to that problem is understand at the outset what the rules of the game are. And if the lawyers agree in advance that this is the way in which witness statements will be done, either explicitly or implicitly, then that problem is a long way towards being solved. But if one side is going to cheat, they cheat, and frankly, it probably comes out in the wash. What panel doesn't know when they're reading something which has been over-lawyered?
And I think also, I mean, this notion of guerrilla tactics, and I'm assuming that the people in the audience who practice arbitration are not engaged in these types of guerrilla tactics. But if I said to you, for example, you know, do you agree with me that an arbitrator should have some power to sanction a party who engages in excessive document requests or last-minute document production or introduction of evidence at a late stage or intentionally trying to find a conflict with a member of the panel? You know, would you agree with me that an arbitrator should have some power to deal with those issues? I would have to assume most people would say yes. And then the question becomes just figuring out, all right, again, you know, what are those rules? I just want to make sure everybody understands what those rules are. But to suggest that an arbitrator should not have the power to deal with those issues because he or she only has authority over the parties, I have some difficulty with that proposition if ultimately what you're looking for is a fair and a neutral forum for the adjudication of this matter.
Do you think that arbitrators may have the power to exclude counsel based on their inherent quasi-jurisdiction in the case of egregious conduct?
That's a really tough question. I think that would be sort of the extreme sanction, if you will. You know, you're balancing a party's right to choose his or her counsel versus the right to a fair proceeding. There's actually some controversy with respect to the LCIA rules that were adopted in October of this year, because in terms of the remedies that are available to arbitrators under the LCIA rules, there's issues in terms of the availability of arbitrators to, one of the things they can do is they can impose any other measure necessary to fulfill within the arbitration the general duties. And you know, the other sanctions in terms of written reprimands or written cautions as to future conduct, you know, does an arbitrator have the inherent power or jurisdiction to exclude counsel? I don't know that there's a clear answer to that question. But if it impacts on the fairness of the arbitral process, all things being equal, I would rather be in the position of defending an award or the validity of an arbitral award where counsel on the other side has been excluded as the result of extreme and inappropriate conduct versus the opposite situation of an arbitrator having allowed counsel who under extremely egregious circumstances has displayed completely unethical conduct to continue to participate in an arbitration. I don't know what your feelings are on that, Joel.
Well, I got I don't disagree with you, but I have two observations. It's very easy to describe the interorum situation where there's been behavior which is so horrible that something has to be done. I mean, take bribery, for example. If it becomes apparent that a lawyer has bribed a witness or suborned perjury in some other way, that's an easy example, but that doesn't happen. Typically, you've got gamesmanship which is being played, late production of documents, surprise witnesses at the last minute. That's much more difficult to deal with, and there are a lot of other procedural things that a tribunal can do to deal with that type of situation, short of capital punishment, if you will. The other thing that I find interesting is that the LCIA rules say that as sanction, the tribunal can admonish the lawyers, or that's not the exact word they use, but
written reprimand.
Written reprimand, well, big deal.
Yeah.
Written reprimand, then goes on to say anything else, or there's this basket clause. Can't believe there wasn't a discussion within the chamber of the LCIA as to whether or not the LCIA should go further and say explicitly what the ultimate sanction should be. And I take it with some degree of interest that the rule doesn't say remove counsel. It just says anything else, which is sort of avoiding the issue, frankly, probably because the drafters of the rules couldn't agree. But again, I think it's easy to identify the horrible situation, and in a horrible situation, I agree with David. I'd much rather be defending an award where a tribunal has done the right thing than the other situation where you've got an award which has been tainted by bad counsel behavior, the tribunal doesn't do anything, and then what have you got? But I think that's not the real issue. I think the real issue is gamesmanship and what degree a tribunal has over the parties and their lawyers to make sure that the process is fair. This comes back to the old expression, whose arbitration is it anyway? The parties agree to arbitrate, they agree to appoint arbitrators, and then at some point in time, and nobody knows when that is, the process moves across the table from the parties to the arbitrators, and you have arbitrators that are empowered, they're empowered, they have a duty to make sure that the parties are treated fairly. Well, treating parties fairly means you've got to make sure that one side doesn't get away with cheating. And then you have parties saying, well, hey, I never gave you jurisdiction to do that, to order that I produce all my documents in 12 minutes. But the fact is you have. By appointing an arbitration tribunal, you've empowered the tribunal to exercise the powers that the model law requires in order to ensure a fair process. So I think there are ways of dealing with situations that fall short of excluding counsel. In reality, you won't find many cases where there's been bribery and so on. There will be, but they're not going to be the common situation.
Do arbitral institutions have anything to offer in terms of dealing with these questions? Or merely making suggestions in terms of rules to consider or guidelines to consider?
I suppose the LCIA has put its foot in the water by enacting Rule 14. As David correctly says, if you adopt the LCIA as your institution, you're using their rules, and they've given the tribunal that power. What's interesting is that the LCIA hasn't given itself that power. And you would think, logically, that if arbitral tribunals are supposed to be ensuring that the arbitrations are being conducted properly, and you're paying a lot of money, and by the way, I'm not being critical of any institution here, but you're paying a lot of money for LCIA, ICDR, ICC. The ICC, for example, you're paying a lot of money for and what you're buying is ICC control over the quality of the awards that are issued. They make sure that the awards are properly written, that they're properly formatted, that none of the issues are forgotten. But the interesting thing is when the LCIA makes a rule about counsel misconduct, it doesn't itself give to its own court the ability to deal with counsel. It sort of fobs it off on the tribunal, which is easy. But you're not getting, logically, I would have assumed that the LCIA court would have been the body that would deal with counsel misbehavior so that the tribunal could say to the court, hey, I've got a problem here, I've got a lawyer who's done this, can you do something about it under your own guidelines, under your own policies? So I think the short answer is that the institutions thus far give you nothing. There's no other institution that's gone as far as the LCIA. I don't think that the ICC has any ability to deal with lawyers in front of tribunals that it controls. So I don't think the bodies do it. And maybe that's the real answer. Maybe that's where the discussion should go. It should go to arbitral institutions and to see whether they can exercise any degree of control over counsel behavior.
It's an interesting question because when you think about it, the person or persons that are best placed to determine whether or not there's been unethical conduct by party representatives are the arbitrators, right? But then you're faced with the issue that I raised earlier of arbitrators sort of playing this dual role of deciding the issues before them and also sitting in judge of counsel conduct. But then the question becomes as well, if the arbitrators don't have the power to sanction and, for example, to disqualify counsel, who should have that power? Is that a power that the court should have? I mean, from a practical point of view, if you're talking about efficiency and speed and flexibility, you don't want a situation where you're going to have to submit an issue of counsel conduct in the middle of an arbitration to a court in the seat of where the arbitration is taking place.
I think another ethical issue that arises, and that one always gives me the jitter, is pre-appointment discussions. That's an important one. You always have to tiptoe in terms of reaching out to get to a person to see if that person is capable to acting out as arbitrator. So what are your thoughts on generally pre-appointment discussions with potential candidates?
That's a bit of a minefield. You know, they say in real estate it's location, 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 and in arbitration it's arbitrator, arbitrator, arbitrator. So you have this major advantage of you get to choose who the decision maker is going to be. And I think everybody understands, and on some level we have an obligation as counsel to do our due diligence. And so what does that involve? So you ask people questions about their experience with a certain arbitrator. You search online. You know, if you're dealing with a retired judge, you look for past decisions and so on and so forth. But the question becomes as well, can I contact someone? Can I conduct a pre-arbitration interview, if you will, with a potential arbitrator? And if the answer to that question is yes, then what can I discuss with that arbitrator? I think most of us would agree and have had the experience of actually conducting, and again, I'll use the term very, very broadly, interviewing. I'm not really sure it's an interview per se, but having had ex parte communications with an arbitrator or potential arbitrator, I don't think there's ethically anything wrong with that. The question becomes as well, what can you discuss with that arbitrator? And the Chartered Institute of Arbitrators has a guideline of topics or subject matters that can be discussed. My rule of thumb, and while I don't necessarily invite counsel to sit in on my initial call with a proposed arbitrator, is I function under the assumption that counsel, as if opposite counsel is sitting in on the call, such that you want to make sure that it's done the right way, because it can be a minefield in terms of going too far, taking too long. I'll let Joel touch upon it a bit in terms of what you can or should not cover.
It's another area where there's profound cultural differences. When this was raised in a session similar to this a couple of weeks ago in New York, the Europeans had a far different view as to what arbitrator selection meant. And arbitrator selection to them means nothing if you can't collect a great deal of information from the arbitrator before he or she is appointed. And the only way of really getting good information about an arbitrator's attributes is by speaking to the arbitrator themselves. Whereas the Americans in the room found the whole discussion abhorrent. To a man or to a woman, they said, well, we never do this. And the arbitrators in the room said, we would never allow this to happen. I think in Canada, we're in a bit of a middle, at least in my Toronto experience, is that arbitrator pre-appointment discussions are relatively common, although interestingly, I did speak to at least one retired judge who's acting as an arbitrator who said he would never participate in it because he found it insulting. After spending 30 years on the bench or 20 years on the bench, he said, if you don't know enough about me, then go somewhere else. But discussions with party appointees is not uncommon. Typically, you can and should speak to an arbitrator about the names of the parties for conflict purposes. The general nature of the case, by which I mean it's a breach of contract case, it's a contract interpretation case, it's a case involving the fixing of rents over rights of way, so that the arbitrator can tell you, well, I wouldn't know a right of way or a rent if it fell out of the sky and hit me in the forehead. You go somewhere else. You certainly want to talk to potential appointees about their availability, how busy they are, how much time they'll have to schedule a hearing, how much time they'll have to write their award. One of the things you might want to talk about, and I say this because it became an issue and something I was involved in recently, is whether or not the arbitrators know any of the witnesses. Because it can be problematic if you appoint a panel and go through a year of pre-hearing process, deliver your witness list, and the arbitrator says, well, that witness is my first cousin. That can be embarrassing. So that type of thing should be canvassed. The real issue is whether you do it with the other side present or not. And I think that as long as you're careful, doing it yourself for your own party appointee makes the most sense. It is, after all, your client's right of appointment. You want to make sure that you have a good record of how long the meeting took place. You want to have a good record of what was said. I probably don't favor recording the meetings because I find there's very Orwellian about recording discussions, but good set of notes would be a good idea. The arbitrator who's being interviewed, and I will use that word, should keep his or her own notes of the discussion so that nobody can afterwards say that anything improper was canvassed. There's a different dynamic when you're talking about appointing a chair, which maybe, David, you might want to start on.
Sure. And I mean, just to the point
Just before that, should the client be there with you when you have these interviews with your party appointee arbitrator?
I've never done it, but there's a good school of thought that says that parties should be involved as much as possible. For example, parties should be at pre-hearing conferences wherever possible. I don't see anything wrong with having a party present so that, I mean, it's a bit of self-protection. If you as a lawyer appoint an arbitrator and you go to your client and say, well, I met this guy and he's got the goods, and then he doesn't, or you lose and the client feels he doesn't, well, protect yourself by having the client there. Does that present in and of itself an ethical issue? No. If the interview is done properly, the fact that the client's there doesn't make a difference as far as I'm concerned. But I've never done it.
The flip side of that, it's a good question. I would not have my client, it has happened before, not in my experience, I would not have the client deal directly with the proposed arbitrator in terms of asking the arbitrator questions about his or her competence. You know, the analogy in terms of what the standard is like buying a car and buying a new car. And in this case, the analogy is, well, you can kick the tires, but you can't take the car for a test drive, right? So you're trying to determine whether or not the arbitrator has the competency for this particular matter. So do you have experience in construction law matters, for example? I would assume everyone would agree that that's a fair question. Once you start crossing the line in terms of the facts of the case, the position that parties are going to argue, trying to fish for things like, well, with the respect to the interpretation of contracts, are you a strict constructionist, or are you going to allow more room for flexibility, and how would you deal with this scenario? I think the problem there is you're crossing the line. So again, my rule of thumb, assume opposite counsel is sitting with you while you're conducting this interview of the proposed arbitrator. The Chartered Institute of Arbitrator has some very good guidelines for arbitrators and counsel. You know, if you're going to have a meeting, probably better not to do it over lunch and drinks. Probably better not to have a 3 or 4 hour, pre-appointment interview, if you will, and sort of, keep things to the minimum, because you're trying to, of course, on some level, we all try, we pull out our crystal ball and are trying to maximize the chances of getting an arbitrator who's most likely to decide in your favor. But you also have to be careful in terms of an apprehension of bias, which of course, again, is going to potentially subject you to problems down the road. I completely agree with Joel. Identifying who the parties are, who counsel is, who potential witnesses are, all of that, as far as I'm concerned, is fair game, because you're setting the stage and you're identifying potential conflicts at the outset, which I think is hugely important.
And you think it's good soliciting disclosures from your arbitrator in a written form to avoid that a situation of conflict may arise in the context of the arbitration once the panel is appointed?
Oh, for sure. I mean, a lot of arbitral institutions actually have the requirement that arbitrators sign a statement of independence and impartiality. To the extent that they don't, I have absolutely no issue with asking for that. I mean, for that kind of a statement from an arbitrator, just to ensure that you're preserving the integrity of the process. I mean, once hundreds of thousands of dollars have been spent on legal fees and you're 2 years into a process, and you find out on the eve of the arbitration that there's some conflict of interest between the arbitrator and one of the parties, I mean, that's just an absolute disaster. Availability is a huge thing. It's always one of the first questions that I ask in terms of discussions with arbitrators. Try to give them a sense of, again, the bare bones nature of what the dispute is actually about, who counsel is on the other side, if you know what that is, and a general sense, very important, of, well, when is it likely, like, what are we talking about here? Are we talking about a hearing that's going to take place in 3 years from today? Or are we talking about a hearing that you guys need to take place in 2 weeks? Because I don't have any availabilities on my schedule till the fall of 2016. Well, that answers your question right away as to whether that arbitrator is a good choice. So.
In the scenario where we're talking about a panel of 3, so David, you've appointed your arbitrator. Joel, you've done the same. How do you conduct yourselves in terms of offering or not guidance to your arbitrator for the selection of the chair?
Well, it depends how the chair is being selected. Frankly, my preference is the parties select the chair. where the parties can agree on a chair, that's the best solution. I think your question is really directed at when the arbitrators themselves are selecting the chair. And the interesting experience I had is that we proposed to a tribunal, to the two-party appointees, that we would give them a list of the people that we thought would be suitable chairs in a way that the appointees would not know who picked what name. So we gave a list of 10 people to the two appointees, and they picked somebody on their own who was not on the list because they didn't, they just preferred the third person. Whether that was a good idea or not, we don't know, because the case never went to hearing. But I think it's more difficult. I think that, again, there has to be some understanding between the parties as to what the process will be. And if there's an understanding as to what the process is, then nobody can complain. So if the process specifically contemplates private discussion between a party and its own appointee as to who the chair should be, and both sides know that that's happening, that's fine, provided that the same limitations on the scope of that discussion that we talked about a few minutes ago can continue to apply. If there is to be no communication between the parties and their appointees with respect to the selection of a chair, then there should be no communication with respect to the selection of a chair. And that's one of the guidelines that the IBA actually spells out quite explicitly. So again, it's a question of coming to terms with what the rules should be and complying with the rules. That's the way I would approach it.
I completely agree with Joel. I mean, in a situation where you have a three-member panel and the two party-appointed arbitrators nominate the chair, I've never had the experience of discussing with our nominated arbitrator who I think should be the chair. I mean, that's just not something under those circumstances that I found would be appropriate. Not only would I not approach them, I'm never consulted by the party-appointed arbitrator as to my thoughts on the matter. My view of it is once I've appointed my party-appointed arbitrator and the other side as well, it's for the two of them to decide who the chair is going to be, and the party should really, unless it's a process as Joel describes where you can agree in advance, all right, here's a list of 5 people that we would both be comfortable with, that's fine. But short of that, I don't see that as appropriate conduct under those circumstances.
And once we go ahead, the panel is constituted, then there's the issue that often arises in various jurisdictions about ex parte communication with the arbitrators. What's your take on that?
I mean, to me, once the panel is constituted, unless you're dealing with extreme circumstances of another party, some interim urgent relief or circumstances where the other side has been convened to a hearing and, deliberately and repeatedly fails to take part in it, to me, there should, at that point, once the panel has been constituted, there should never be any form of ex parte communications with the arbitrators, quite frankly, on pretty much any matter.
I think there's one exception to that, and I agree with you, but there is one exception, and that has to do with financial arrangements. If you're in an arbitration where the parties are paying for their own appointee, which is probably not the best practice, but if you're in a situation where you're paying for your own appointee, I think that's a carve-out where you're entitled to communicate with the arbitrator about the rendering of accounts and the format of the accounts and so on.
Yeah, that's a very good point. It's also a really interesting question in terms of how you deal with payment arrangements with arbitrators as to whether or not you're better off having sort of the chair deal with these things and I think that also raises some issues in terms of parties paying their own, but I mean, I know it happens all the time, so.
Do the IBA guidelines and the LCIA annex deal with that in terms of ex parte communications?
No, they deal with ex parte communications. The Chartered Institute has guidelines that deal with it. And so, I mean, they don't have guidelines once the panel has been appointed, but generally the broad categories are ability, availability, expertise, experience, willingness to take on the file, and potential for conflict of interest. Those are sort of the guiding principles, which are sort of fair game for questioning. And sort of once you go beyond that, you've probably strayed too far.
So is it fair to say that the guidelines, the IBA guidelines, they do represent the essential expectations of parties that are familiar with international arbitration? Like you said, they're not controversial, so there shouldn't be too much resistance in terms of agreeing to them contractually.
Well, I think, as I said at the outset, there's still resistance in terms of this notion as to whether we need them in the first place. And because of the fact that we're dealing with relatively new rules, the IBA guidelines came into effect in May of 2013, and the LCIA rules just came into effect in October of 2014. We're sort of at its infancy, and it's something that's going to continue to be talked about. It's still a controversial subject, and I'm sure this is not going to be the last forum that debates this issue in terms of the overall merits of it and what rules should govern and whether they're required.
I tend to agree with that. If you look at all of the IBA guidelines, you're not going to find something in there that will catch you by surprise as to what lawyers can and can't do during the course of an arbitration. The one exception being there is a rule in the IBA guidelines. It's a guideline, not a rule. There's a guideline that empowers a tribunal to remove counsel where there's a change in party representation made that has the effect of presenting a conflict with the arbitrator. In that particular case, it's Rule 17, the tribunal does have the power to remove counsel. And I would think that of all of them, that's probably the one that parties might say, well, wait a minute, we can deal with that if as and when it happens, but I don't want to, at the outset of the process, give the tribunal the power to tell me who I can use as a lawyer. But apart from that, there's nothing surprising.
Yeah. I mean, interestingly, on the LCIA rules, which, as I said, become mandatory if you're subject to an LCIA arbitration, there the rules expressly provide that any change in counsel has to be subject to the consent. I mean, it's framed in a more polite way, if you will, in terms of, the consent of the arbitrator, and the arbitrator has the right to withhold his or her consent if there are circumstances which may impact on the integrity of the process. So under those circumstances, if you've bought into it as a party, your counsel, also any counsel that appears before the LCIA, has to represent that they have agreed to be bound by the guidelines which are attached to the LCIA rules in terms of counsel conduct.
We thought we'd leave 10 minutes for the audience to ask questions. So if any of you have questions, this is the time.
I saw one hand go up.
Anyone?
Great subject. Thank you very much. I'm in awe of the qualifications. I'm hoping you could talk a bit more about the inherent conflict of interest of the arbitrators whose interest financially is to maximize their revenue stream from the arbitration, and the interest of the parties in minimizing the cost of those arbitrators.
Well, that's certainly a point that's made often when parties are critical of the time and expense that's associated with arbitration. And I heard a lot of this when I was down in the States last week, where people saying, why pay people when I can go out and get a neutral federal court judge who is not dependent on me at all? Where arbitrators are dependent on a revenue stream, they're dependent on a revenue stream. The fact of the matter is, you're going to, and I hope this doesn't sound naive, but the fact of the matter is that you're going to pick arbitrators based upon their experience and reputation. Arbitrators who have a reputation for stringing things out to maximize their revenue stream will probably develop a difficulty in being retained. And the other point, the corollary to that is if you're hiring an arbitrator because he or she happens to be very good at what she's doing, then that person won't be dependent upon you as a source of revenue because they'll be busy. So I think that the invisible hand, if you will, probably has a lot to do with that. But there is no doubt that when you're arguing a motion in front of an arbitrator, and the motion is to have the arbitration tribunal find that they have no jurisdiction to deal with a claim, and it's a really interesting case. It's really interesting. Quite apart from the revenue aspect, it's just a really interesting case. You do think about the fact that there might be a predisposition to find that you have jurisdiction. And that's, you can't develop a system that does away with human nature. So I think that's one of the features of arbitration that you have to know about going in. I don't think there's a perfect answer to it.
Yeah, I completely agree with Joel. I mean, in my experience, and I've heard this a lot, in terms of the conflicting position between the arbitrators and issues that may arise, the notion or the vision of an arbitrator who, is getting paid for this, as far as I'm concerned, is sort of a very short-term vision, because you're looking for a revenue stream, but you're looking for a recurring revenue stream, right? It's not, as Joel said, it's not gonna take very long for someone's reputation, especially in, whether it's a domestic arbitration. I mean, you're not dealing with, even 15 or 20 people who practice in the area. It's a small community. Same thing in the national, more and more people are getting involved in international arbitration, but the well-known international arbitrators have developed a reputation for a reason. So, as an arbitrator, my selfishness, if you will, is going to be in rendering decisions that I know are well-founded, or that I think are well-founded, while ensuring that I'm giving each party the right to be heard, but also controlling the process as you would expect an arbitrator to. That's the reputation that I would want to develop as an arbitrator. So, the fact that somebody may attempt to, file dozens of motions or, late document production requests, and I say, hey, this is fantastic, I'm increasing the amount of time I'm spending on this file, is a very short-term vision, because if I don't handle it properly, it's going to bite me in the long run, and it may be the only mandate I get.
Hi. I had one question. It was, I'm sitting on a panel where 3 arbitrators. Obviously, the counsels are preparing their documents and they're doing the presentations of their work. And as time is going, there seems to be always a prolongation, extension of the process. And it's a mutual agreement between all parties. So they'll say, hey, we'd like to extend for 2 months. We need to interrogate. We can't get the expert. And the more you go on, it's really very long, the process. And you always have in mind, I want to give fairness to the process. And they agree, the other party agrees to the extension of the delays. What kind of practical solutions you put into place? Just curious.
Bill Horton, who's not here today, Bill Horton has an expression. He tells lawyers, don't agree with each other, because the more you agree, the less I can intervene. That is the truth. But, that goes back to the expression I used before, whose arbitration is it anyway? At some point, the process becomes more important than the ultimate prolongation of everything that happens. And that's why it's important, by the way, to have the parties involved at every pre-hearing or at every pre-hearing conference, because the parties should see what's happening between the lawyers. And very often, the degree of cooperation between the lawyers is way over the top, insofar as their clients are concerned. And one message that a panel might convey to parties in that situation is, you can agree, but we just don't have. If you want to extend this once more, we're looking at a hearing 5 years from now, because we just don't have the time. And we set a hearing date, and that hearing date is going to happen, and you've got to squeeze it in.
Because we did the preliminary meeting. We tried to set up the guidelines. We did everything according to plan, but nothing. Yeah, at one point, that's what it is. You have to.
At some
be
point, the
more
panel
stern.
has to say enough's enough.
Yeah.
This is it.
But I think in a situation, for example, if an arbitration panel has been constituted and, things are not moving and the arbitrator has not heard from the parties, I would much prefer diligent arbitrators picking up the phone or writing to counsel saying, counsel, what's going on? Where are we at with this? Haven't heard from anybody in 2 months. I'm totally fine with that. But I've also been in situations where I'm in one currently, for example, where the parties are trying to find a way to settle the dispute and have basically agreed to a standstill agreement. And the result of the standstill agreement is the arbitration is just effectively continuing to be postponed for periods of 6 months at a time. Now, because it's a contractual arrangement, if you will, I don't think at that point, I completely agree with Joel. The arbitrator can say, look, you guys can continue to suspend this thing, but just to let you know, if you suspend it beyond this point, my next available dates are in 2017, so that nobody is surprised. That's fair game. But if you have parties who are in agreement with respect to a process in terms of, for example, we're trying to settle this, let's hold off for 6 months, I don't think it's the place of an arbitrator at that point to say, well, no. I'd like document discovery to take place next week. I just don't see that as something that's, because generally speaking, if both sides agree, I think it's sort of hard to imagine that there's some impropriety, if you will, in terms of them both trying to intentionally delay, the arbitration. But it's a tricky line, because you do want an arbitrator, especially when you don't have agreements between counsel and these delays start to creep in, and there you see examples of people trying to push things off too far. There you do want a situation where you have an arbitrator that's gonna step in and say, no, this is gonna go more quickly, this is gonna go more rapidly.
Again, as long as the parties understand what the consequences are. And by the way, to the point of letting things languish, in the few arbitrations I've done, we've never had a situation, never, where the next pre-hearing conference wasn't on the calendar.
Yeah.
Anytime anything happens, you schedule another pre-hearing conference so that you know that there's a date on which the parties have to come back and tell you where they are.
Yeah,
That's the best way to deal with it, especially in the context of where you have reference schedules in ICC arbitrations. That's the best tool to deal with,
Yeah.
respecting a certain measure of delays.
I mean, even in certain circumstances, for example, in domestic arbitration, of course, depending on what side you're on, and of course, nobody wants to delay the arbitration once it's started, unless you're the respondent to the arbitration who may have a large sum of money to pay, and then the position may be slightly different. I have no problem with an arbitrator saying, all right, well, how long do you figure you're gonna need to get this to a state of readiness for us to get to a hearing? And if you come up with an answer of 6 months and they say, well, fine, here are the dates I'm gonna book in April of 2015, and you guys work your schedule backwards. I don't really have a problem with that, because, then as you approach that date in April for the hearing, it becomes much more difficult to, when you have a busy arbitrator who's reserved a week of hearing time, to say, well, we just couldn't get our stuff together and we're not ready. So, I don't have problems with arbitrators taking control over the process, again, ensuring that both sides are being treated fairly.
I hesitate to ask this because I think it's a question that could actually take up an entire session. What are your thoughts about the advent of social media on the conflict of interest and potentially communicating with arbitrators via LinkedIn, Twitter, which Facebook? Joel will tell you I have no friends, so it's not a problem for me. But you look at the next generation of people who are practicing in this field, and they've grown up with social media as part of their life. And, to have well over 1,000 contacts is not out of the ordinary. Do I have to immediately unfriend, disconnect, cut off everybody once appointed as an arbitrator, or vice versa in the process of appointing an arbitrator?
Well, you have at least 2 friends, Janet.
Thanks.
3.
I pay them well.
Yeah, I happen to disagree with somebody that we both know quite well. I don't think things like LinkedIn are a tremendous problem, and my own view is that the more ubiquitous it becomes, the less problematic it is. If you've got 1 million friends, well, they're not friends. If you've got 10, that may be an issue, and you're interacting within a very small group. So I don't happen to be fussed by things like LinkedIn. I would be fussed if you were a member of a regular foursome playing golf every Sunday.
Right. But what about, do you make a distinction between LinkedIn, which I think most of us in this room would equate with professional contacts,
Right.
versus Facebook, which would be more personal?
I can't imagine any circumstance where I would open a Facebook account, so you're asking the wrong person.
Yeah, that's a very interesting question. I actually do have a Facebook account, and it would not dawn on me to connect with someone on Facebook who could be a potential arbitrator in a file, whereas for LinkedIn, I would have no issue with it. It's sort of also, a similar type question. If I happen to run into Mark, for example, at a restaurant, and I've appointed him as a party-appointed arbitrator, do I have to disclose to the other side that, 5 months ago I saw Mark at a restaurant? How far does it go? Even LinkedIn, so for example, I don't know about you, Joel, if you would decline a request, if I send you a LinkedIn request this week, if it's gonna be declined, because who knows, I may appear before Joel one day, and, the information on there is really sort of business information.
There would be a problem because you're having this conference with Joel
Well, there
right
you
now.
go. So would Joel have to disclose that we participated in a panel together such that, I'd be precluded from ever appointing Joel as an arbitrator or vice versa? How far do you go with those things?
My short answer to you is that if we were doing a case right now, I would wait until the case was over to accept the
Yeah.
invitation. But if I had accepted an invitation from you 3 months ago and you approached me to be an arbitrator, I wouldn't think about disconnecting the connection, nor would I think twice about disclosing the fact that we were linked into each other. To me, if we go that far, we're going to destroy the business. We're
Yeah.
going to destroy arbitration because, you know, I was challenged once after I issued an award on the basis that I was in Singapore at the same time as somebody else at the IBA annual meeting. And I should have disclosed that because we had a close personal relationship because we were in Singapore at the same time. Well, you can get pretty stupid about these things. So social media, I really think is overstated as a potential problem. I actually believe that.
I agree in terms of the LinkedIn contacts. The next analysis on it, and I won't interfere with the break here, but, you know, I get constant blurts of people posting information, articles, commentaries, making, doing case analysis, whatever, on various LinkedIn, or from LinkedIn contacts that I have. Could you be backdooring communication with an arbitrator in that process? Do you know where I'm going?
Yeah, I do. On an active case, you mean?
But,
Yeah.
but I'm thinking that, you know, I candidly can't really tell you who I'm linked with, because
Yeah, but I
I
don't understand totally how LinkedIn works because I'm a lazy LinkedIn user, but it seems to me that if you were counsel in front of me and we were linked and you posted an article on best practices in arbitration, I probably shouldn't read it. I mean, I don't have to read it, I presume. You know, so that just becomes commonsensical. The fact that you post something that 1 billion people, I mean, I could find that on Google. You know, you don't have to be linked in to become a recipient of these types of things. So I'm not fussed by it.
So with a Google search, is you as arbitrator are actively going out looking for the information.
Yeah, but
On LinkedIn, I'm sending it to you.
I have to actively read it. I have to make a decision
But
to read it.
does it create fodder for conflict argument?
Only if we're going to go to the extreme
Yeah.
and you know, you can't have an arbitrator who's ever even thought of your existence.
Yeah, I mean, the flip side of it is you want arbitrators who are up to date, who are familiar with the latest developments, right? And, you know, with the number of blogs and the cluers and everything else you get out there, if that was the standard, we'd probably have to find a new practice area because there would be nobody to plead before. So I think,
But I'm told that it's a real issue in the US. Less so up here, but in the US, it's a significant
Everything's an issue.
Because in the U.S., let's be blunt, in the U.S., a great deal of activity is, there's a whole practice post-arbitration award of going back and investigating the arbitrator to find out, and I'm a victim of it, to find out what really is the relationship. And this is all after the fact, and there's a burgeoning industry, and if they want to destroy their arbitration practice, God bless them, but, you know, it's crazy.
C'est tout? Merci beaucoup,
you.
messieurs.
Thank you.
Much appreciated. Thank you for being here.